Please.
Thank you very much.
This hearing is in the matter of case number CFI 004-2022 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Watson, Farley and Williams, Middle East LLP. Lead counsel is Ms. Charlotte Bijlani. The defendant is represented by Al Jalaf Advocates and Legal Consultants. Lead counsel is Ms. Amna Al Jalaf.
Yes. Let's move. Ms. Bijlani.
Sir, this is a return date in relation to the freezing order issued by you on the 14th of January. As directed, we served the order on the respondent by courier and by email, and various certificates of service have been filed with the court. We also served the order on anyone we thought who may be or have dealings with the aircraft, including the General Civil Aviation Authority in Dubai, Fulcrum Aviation, who we came to learn is holding or had been holding the aircraft, and ExecuJet. Following the service of the order, we received an email on the 19th of January from Clyde & Co, who stated in their email that they've been instructed by Mr. Ahmed Abu Hashima, Mr. Kamal Abu Ali and Mr. Amir Shendi to act as their legal representatives in this matter, and that we would receive their reply by Friday the 21st of January. By an email the same day, Watson Farley Williams asked the question of Clyde & Co on what basis they are instructed by these individuals. Are they instructed as shareholders and or managers of the respondents? That same day, we received a reply from Clyde & Co explaining that they had only been instructed and were still dealing with the client onboarding process, but they didn't answer the question that had been raised. On later, again, on the 19th of January, on the 20th of January, Watson Farley Williams asked the question of Clyde & Co again, on what basis have you been instructed by these individuals? At midnight UAE time on Saturday, so during the course of the weekend in the UAE, we received a letter from Clyde & Co stating that they act for only two of the individuals they had previously named, Mr. Amir Shendi and Mr. Ahmed Abu Hashima. And they go on, we've shared this letter with the courts. I don't know if you've had sight of it, sir.
I've got it in front of me, yes.
Okay, you'll see from paragraph 2.1 that they say that they're instructed by Mr. Ali and Mr. Abu Hashima, and that they're currently listed in the respondents' books as its shareholders, and that Mr. Abu Ali, Mr. Shendi, and Mr. Abu Hashima are listed as the respondents' directors. They refer to a letter that was served on the applicant on the 22nd of April 2021, and which has been exhibited to the affidavit of Mr. Khaldoon Al-Aini, which has been filed with the court, explaining that various individuals were going to be appointed as permitted individuals under the management agreement, and that a transfer of shares would be happening in the company books. It's clear that the transfer of shares, according to what Clyde & Co have told us, has not been registered in the books of the company. The respondent company is an offshore entity incorporated in the Jebel Ali Free Zone, and according to Article 34 of the Companies Regulations 2018, a director holds office until his successor takes office, or until his earlier death, resignation, or removal by resolution. According to what Clyde & Co have told us, Mr. Ali, Mr. Shendi, and Mr. Abu Hashima have been listed as the directors at the time of receipt of the freezing order. We don't know if that's now changed. On the evening or during the evening of Sunday, i.e. yesterday, Saturday evening, we came to learn that efforts were being made to remove the aircraft. We were in contact with the GCAA. Our client was in contact, the applicant was in contact with Falcon Aviation, who were holding the aircraft on its hangar. I personally spoke to the GCAA at 1:30 a.m. on Sunday morning, and it has now come to light that the aircraft has left the UAE in breach of the freezing order. It had been understood that the aircraft was en route to Istanbul, but it appears that the aircraft may now be in Cairo in Egypt. It's not known if the aircraft flew with all due safety in place, and it's not clear whether it had the usual tracking equipment reinstalled on the aircraft. It's understood that the aircraft was en route to Istanbul for permitted safety works, but somehow the aircraft, as far as we know, has ended up in Cairo. The applicant's position is that the directors, as named by Clyde & Co, have been on notice of your freezing order. And whilst they say that they are about to transfer, that whilst they say that the shareholding is about to change, they have clearly held the position of director at the time of receipt of your order. Although it's stated earlier in the letter from Clyde & Co that Mr. Shendi seems to have resigned as director from the 21st of April. But the applicant submits that the other two individuals seem to have maintained office, and that it's appropriate for the court to make an order against those individuals. And we would submit that that is for the freezing of their assets in the jurisdiction of the UAE. I suspect you may want some further evidence from the applicant in relation to the involvement of Falcon Aviation. All of this did happen extremely quickly over the weekend. So we and the applicant are in the process of trying to establish some of the facts and how the aircraft managed to leave Dubai. But we would expect to submit further evidence about the complicity of Falcon Aviation and anyone else in allowing this aircraft to be left. And after due consideration of that evidence, we would ask for an appropriate ruling against those individuals. We would also like to raise that we consider it to be appropriate for there to be a prohibition against changing the register of the respondent company, so that they're not allowed, if they haven't already, to change the shareholding or the positions of the directors.
Well, what does the registry currently show as regards shareholding and directors?
We're unable to obtain any information about the current shareholders or directors without a court order or without the cooperation of the registered agent of the company.
I'm not quite understanding why that should be. Isn't I know it's offshore Jebel Ali, but isn't that a public register that's open to inspection?
No, it's not a public register, sir. It's unlike Companies House in England, where, as you know, you can go on and get information very easily. It's a closed register.
Right.
I should also point out, sir, that the respondent did not provide the affidavit that you directed should be provided within 48 hours of service of your order, setting out its assets. So that has not been complied with. I've also had no contact from the legal representative of the respondent that is participating in today's hearing.
Right. Well, let me ask Miss Al-Jalal.
Yes.
Who do you represent? And
I represent.
and on whose? Can you tell me?
Sir.
I want to know not just who you represent, but also on whose instructions, which individuals' instructions you're acting.
Yes, I represent A&K Trading Limited Company, and we just instructed to represent them recently, and we acknowledge service just today. So we are attending this hearing to request a permission to submit our defend and all the requirement documents.
Yes, and who's instructing you? Who are the individuals from whom you get your instructions?
The director of the company.
And who is that?
Mr. Ahmed Buhashima. We submit a power of attorney. I don't know if because we tried to submit it early morning today.
I haven't seen that as yet. That doesn't mean the court hasn't got it, but I haven't seen anything yet.
Yeah, I think the register, they have it because they respond to our email, but right. maybe not yet in the system.
Yes. But the man from whom you're taking instructions, Mr. Abu Hashishima, is said by Clyde & Cove to have sold his shares in the company.
Yeah, but this is not reflected in the book of the entitlement of the aircraft and the company. Okay.
Well, on your instructions, who are currently the shareholders and the directors of the company?
As a shareholder, we just instructed by Mr. Ahmed, who I communicate with him just yesterday. So I'm not yet reviewing all the document in order to respond to many questions so far. So that's why I request time in order to reply.
Yes. Well, I think you ought to be able to find out very quickly who are registered as the shareholders and directors at present before any change in the company's registry. Are you telling me you don't know the answer to that at present?
I don't know exactly all the details of the transfer the share and purchase of the share, but I know that these shares were sold before the freeze of the aircraft. I think sometime in November, but I don't have all the details of that.
Yes. Well, I see.
So could I just raise one point? I believe that counsel for the respondent is registered as the registered agent of the respondent and will have received all of the papers that we have been serving over the course of the past week, including the freezing injunction, the affidavit, the 2 affidavits, and the court bundle.
Yeah, I received the document and I sent it to client as an agent. I didn't really involve in all the details of the case until they instruct us to do that.
Right. And the one person you've been having dealings with so far is Mr. Ahmed
Yes.
Abu Hashima. Yes.
Yeah.
Right. Well, Ms. Biljani, the question really is what in practice is the way forward? Obviously, the matter's got to be satisfactorily evidenced on both sides in terms of affidavits as to what has happened and what's going to happen next. The aircraft is gone, so there's a problem there, obviously. In relation to any issues which might arise as to contempt, my understanding is the Attorney General has to be involved. And in any event, I'd need affidavit evidence of everything that's taken place. So the only order you're seeking today is an order that you can inspect the registry, is that right?
Well, I think an order that we can inspect the registry and that it doesn't change, but also an order freezing the assets of the current directors, because if they're now on notice of this application, there's a high risk of dissipation. And once any assets go, the prospects of the applicant recovering anything are extremely slim. And we would be prepared to file affidavit evidence setting out what I've raised today very quickly, to satisfy you of what I've told you about the events over the past 48 hours. I believe that some of the individuals have also been communicating with the applicant directly, evidently concerned about the freezing order that had been made. So, you know, I think that it's fair to say that there's been full awareness of your order, and efforts have been underway to remove the aircraft from the jurisdiction.
Well, I understand that. The first question is, when you refer to freezing the director's assets, who are you referring to?
Well, I know the letter from Clyde & Co says that Mr. Shendy has resigned as director, but with effect from the 21st of April 2021.
Yes.
We've seen no evidence of that. And in the earlier paragraph 2.1 of their letter, they say that Mr. Ali Shendy and Abu Hashima are listed as the respondents' directors. And as I mentioned earlier, in accordance with the company's regulations, those individuals will hold office until the successor takes office, or until death, resignation, or removal by resolution. It seems to me that that has not happened, based on what I know at this moment in time.
Yes. And Ms. Al-Jaraf,
Yes.
what do you know about Mr. Abu Ali?
Kamal Abu Ali or Amr? Kamal Abu Ali. I don't know anything about him. I've been contacted by Ahmed Bouhashima to represent A&K in this matter.
Yes. And have you been instructed as to what they've done over the last week since they were served with these documents?
I just they just communicate with me recently, which is yesterday, in order to represent them, and I didn't have the chance even to review the document. They sent it to me, so I really have no further information in this matter.
Yes. Well, Ms. Biljani, I'm very happy that you can have an order to inspect the registry. That seems to be perfectly. And at the same time, of course, Ms. Al-Jalaf can take instructions as to what the current position is about directors and shareholders are on the registry and whatever transfers and resignations there may have been. Now, how quickly can you come back to tell the court the position on that, Ms. Al-Jalaf?
If you can give me 1 week?
No. I'm talking about days. I'm talking about 24 hours or 48 hours max.
Because actually client is not in the UAE, and they are traveling all around the world. So I need really to contact them and get the information from them. So if you give me at least 3 to 4 days, please.
No. This is a modern world where we have emails and telephones and WhatsApps, okay, and I don't know what else.
Just give me 48 hours then.
48 hours is the most you're going to get.
Thank you, but 48 hours, please.
48 hours, yes, please. And I want you to inform the court and the claimants as to who are the existing directors and the existing shareholders who are registered, and what transfers there have been and resignations there have been which have not been registered, and if there have been registration of changes in the last 6 months, I want to know what those are too.
Sure.
Okay. So it's getting full information as to the position, and of course Ms. Biljani can inspect the register and see what the position is. I have a problem, Ms. Biljani, about simply freezing directors' assets. I'm not sure quite what my power is to do that at this stage when I can't be clear what the facts really are. The reality is this, that if current directors have ignored the freezing injunction, then they are obviously at risk of contempt proceedings. I'm sure Ms. Al-Jalaf probably understands what that means, but in terms of contempt of court, were they to be committed for contempt, they could be imprisoned and they could be fined and their assets can be seized, as the order itself says. My understanding of the position is that the Attorney General has to be involved in such proceedings and the court simply doesn't act on its own volition in relation to that. And I don't think the claimants can simply institute proceedings for contempt in the way that happens in the UK. But that's something you may want to check, Ms. Biljani, because I am not conscious of the exact procedure. Are you familiar with it?
No, I'd need to check it to check. I'd need to see what the current position is. But
yes.
So, are you saying that if we furnished you with affidavit evidence of what's happened, would that change the position? Because I think
you've got to do that anyway. I want to know exactly what's happened. But the other thing you need to check is exactly what has to be done if you want to institute proceedings for contempt against anybody. And you need to be clear who it is, who the directors are, who've been served, and so on and so forth. I mean, yes. It is, as Ms. Al-Jalaf appreciates, I'm quite sure, whatever the position about changes of shareholders and directors, the fact is that people who are on the register remain in that position, and if they've been served with the relevant documents and are aware of them, then they're at risk themselves in relation to contempt for not coming back to the court and explaining the position as they should have done under the disclosure order that was made. You're on mute, Ms. Biljani.
So I was just checking a point with my colleague.
All right.
We're just considering whether one other request we could make is to freeze the company license to cease activity for the moment of any kind, whilst we establish what has gone on here.
Well, just remind me what the terms of the freezing order are as they currently stand. I'm just looking for the order. Where have we got it?
Well, there is, of course, the terms at paragraph 4 prohibiting removal of any of its assets from the DIFC.
Yes, but the only
outside.
Assets of the DIFC which you knew of were the plane. Is that right?
Well, it was onshore Dubai, but the DIFC courts had jurisdiction because of the jurisdiction provision. But we had understood that the respondent owns is the plane, which is now gone, it seems. And if there's been an ignorance of the order by the directors of the company, then our only pressure point is to freeze their assets.
Well, I
which is what the penal order, of course, warns.
Well, it warns the assets may be seized. But
yes.
that's in the event of disobedience. But I need to be satisfied about all of that before I could make such an order. That's my point.
Yes.
And I appreciate there's a risk that they may suddenly remove whatever assets they've got. But until I've got the right evidence, I can't make any orders against them. And particularly until I know who really is running the company and what they knew and what they didn't know. I'm just trying to find the order. Here we are. Yeah, so it's in the usual terms of assets in the DIFC and assets outside the DIFC. So it's worldwide in that sense.
Yes.
Yes. Well, the short answer is they're at risk of contempt proceedings and going to prison and having their assets seized should they be found to have ignored the injunction. I'm sure Ms. Al-Jalaf will advise her clients as to the risks they run. I think the real question, Ms. Biljani, is when this matter can come back for the court to be dealt with on the basis of evidence from both parties. How quickly can you put matters on affidavit?
Well, I think we can move rather quickly, but I suppose to some extent we're dependent on finding out what the current register says.
I appreciate that. And how quickly will that happen if I make an order today?
Well, if we can inspect the register by virtue of the order you make today, quicker than the respondent's representative can provide details,
well,
we can. Yes, we can file within 24 hours. I would have thought maybe 48 is perhaps a bit more realistic, but we're obviously very keen to move quickly.
Yes. Monday today. Yes. Ms. Al-Jalaf, when you get instructions, and I've generously given you 48 hours, are you in a position? And what I need from you is some witness statement or affidavit that tells me what the position is so far as the company is concerned and as far as any individuals are concerned who you represent. When I say who, I don't mean the individuals you represent, but the individuals from whom you're taking instructions. That if you are going to represent individual directors on the basis that they're at risk, then you need to go on the record for them as well. But really, what I'm looking for is evidence so I can deal with this matter later this week. And if there are to be contempt proceedings, Ms. Biljani, you need to come before me with the right authority as to exactly what has to be done, and if the Attorney General has to be involved, his position on that. Realistically, yes. Realistically, I think we're looking at Friday of this week, aren't we? Be hard, I think, to get the matter dealt with before that.
Yes.
I just wanted to clarify something. I've been instructed for the company itself and not for the individual. So the individual, which is Mr. Ahmed, he gave me the authority to represent A&K Trading Company.
I understand that. Well, yeah. You may need authority to represent him as well, unless he wants to be.
If he instructs me in his personal capacity, yes, but not in this moment. Yeah.
Indeed, and any other director.
Yeah.
You can tell him, and I'm sure the claimants will tell him that he may be at risk, and therefore he needs to be represented. If he doesn't wish to be represented by you and wishes to represent himself, that's another matter.
Yeah, this will be clear after I submit all the affidavit and documents supporting that.
Yes. Well, I'm going to say that you've got to submit those by sometime. If we've given you 48 hours from now, that takes us to Wednesday morning or Wednesday lunchtime, your time.
Okay.
And that means you've got to get in some evidence by, we better say, Wednesday evening.
Okay.
Close of business Wednesday. And we'll bring this matter back on Friday of next week if the court can accommodate us. I know I've got another return date on another injunction that morning. So I'm not quite sure how the time will work. You may need to liaise with the court about a date.
But sir, the applicant already filed the case only against A&K. It's not that against the individual so far.
Yeah, indeed so. but the order that's made is an order which affects the directors of the company, as you can see from the terms of the order. You have the order in front of you, Ms. Al-Jalab, do you?
Yeah, I just received them. Yeah, I didn't go through all the paperwork, so I will do that today.
Yes. Well, all I need to do is to direct your attention to the penal notice at the very top of the order.
Okay.
Which says that if ANK Trading disobeys the order, the directors of ANK may be held in contempt of court, and the directors may be imprisoned, fined, or have their assets seized. And the same thing is true of any other person who knows of the order and does anything which assists in any breach of it. So that
if the assets was under their authority.
Well, of course,
Yeah.
but we're talking about the directors who, on the face of it, do have responsibility. If they're going to say they don't have it, then I need to know all the reasons for that.
Yeah,
and
sure.
when they resigned and all the rest of it.
Yeah.
So I'm going to say that all evidence to be in by close of business on Wednesday night. And can you liaise with the court between to fix a time when the matter will come back before the court? Is that the best way to deal with it, Ms. Biljani?
Yes, thank you, sir. So can I just clarify? So we'll be looking for a hearing on the 28th of January, ideally,
well, if that's possible, just to let you know my position later this week, I could in theory do Thursday 9 o'clock London time, but I know I've got another hearing at midday that day. On Friday at present, I've got a return date on another injunction in the DIFC court at 9 o'clock London time, 1 o'clock your time. And I don't know how long that's going to last, and probably won't know until nearer the time, because it depends on the response of the enjoined parties. But I think we ought to try and aim for
right, we'd be very happy to deal with the matter, outside past 6 o'clock in Dubai. That's no problem for us.
No, well, any questions whether the court can deal with it?
Yes.
Yeah. It's really got to be then, because next week, 31st of January, 1st of February, I'm tied up on other hearings. And the alternative, of course, is that I don't have to deal with it. Another judge could deal with it if that's the most convenient thing. So I'm going to leave that for you to liaise with the court and come up with a date that makes sense for an available judge. It's obviously better I should deal with it if possible, but if I can't and its efficiency demands that it be dealt with by someone else who can deal with it earlier, then so be it.
Okay, thank you.
All right, are you clear? Is everybody clear about what's going to happen?
Yes, so I think 6 p.m. Shall we say 6 p.m. Dubai time on the 26th of January for the filing of further evidence?
Yes.
And then the date of the hearing will be fixed.
Thank you. And you can have an order now that you can inspect the registry.
Thank you, sir.
All right.
Okay.
Ms. Al-Jalaf, I don't need to stress to you the importance of this from your client's perspective. They need to instruct you and give you full information. Otherwise, they've potentially got terrible problems. All right.
So we have filed a statement of costs for this freezing application.
I'm going to reserve that. I think for the moment it'd be easiest to deal with everything in one go when the matter comes back, and we'll see exactly what the position is then.
Okay, thank you, sir.
Thank you.
All right.
Thank you very much.
Thank you very much.
Thank you.
Bye-bye.
If you'd like to sign out, I'll have a word with the associate. So if you'll both sign off.
Okay.
Okay, sure.
Thank you very much.